Welcome back to the deep dive.
Okay, so today we're doing something a little bit different. I want you to just close your eyes for a second, also driving, obviously,
Yeah.
and kind of reset your internal clock.
We're taking a little trip.
We are jumping into a time machine. I want you to look at the calendar, and it is January 18th, 2026.
And it really feels like the future is coming at us faster than ever. The holidays are over, the new year is settling in, but in the tech world, nobody's looking at their resolutions or their gym
No,
memberships.
not at all.
Yeah.
They are all looking at one thing, the court docket.
It really does feel like the whole industry is holding its breath.
Because looming on the horizon, set for this coming April, is what everyone is calling it. Legal scholars, tech giants, probably half of Reddit. They're all calling it the trial of the century.
Big event.
We are talking about the main event. In the blue corner, you've got the world's richest man, Elon Musk. And in the red corner, the world's most influential AI company, OpenAI. It's an absolute collision of titans. These are the founders of the AI revolution, and they are turning on each other. And the stakes.
Wow. We aren't just talking about money, though the billions involved are just staggering.
Oh, the money is almost a side story here. We are talking about the legal definition of the future.
Exactly. This is not just some corporate squabble over patent rights or, a trademark dispute. This is a battle for the soul of artificial general intelligence.
It really is. But here is the thing. Usually when we prep for a deep dive like this, you know how it is. We grab a stack of PDFs.
Right.
We look at the New York Times. We pull the legal briefs from the court filings, maybe some op-eds from Wired or The Verge.
Sure. The usual suspects.
And we did all that. But for this specific deep dive, we found a source that it changes the entire texture of the analysis.
Right. Because if you want to understand a battle over artificial intelligence, why not ask an AI?
But not just any AI, and this is where it gets really spicy. The source for today's breakdown isn't a human legal scholar. It's not some Harvard law professor. It is Grok 4.1. And that detail is so crucial. The user who actually compiled this research, they tried to use Gemini 3 first. That's Google's model.
Okay.
They asked for a neutral analysis of the case, and apparently the result was, and this is a direct quote, unbelievably biased. It kept hedging, refusing to engage with the harsher allegations against OpenAI. It was almost like afraid to offend its cousins in the industry.
Protecting its own, in a way. So what did they do?
Well, in a search for truth, or, at least a different perspective with fewer guardrails, they turned to Grok 4.1.
Which, we have to remind everyone, is Musk's own AI lineage.
It is. So let's just pause for a second and appreciate the meta layer here.
Oh, it's deep.
We are analyzing a lawsuit filed by Musk using an analysis generated by an AI built by Musk's company, about a company Musk helped found but is now suing. The layers of irony here they're thick enough to cut with a knife.
It's incredibly meta. It's almost Shakespearean if Shakespeare, wrote code instead of sonnets. But the mission for this deep dive is to unpack the top 10 arguments that Grok 4.1 identified.
And it ranked them.
It ranked them from strongest to weakest based on judicial rulings and available evidence. And let me tell you, this isn't just dry legalese. Grok did not pull any punches.
No, that's the core of it. Grok has laid out a narrative that includes accusations of a long con, secret diary entries, mentions of moral issues, and these conditional emails that they might change everything.
So let's not waste any more time. Let's dig into the first, and according to Grok, the absolute strongest argument on the table, the broken promise.
This is argument number 1, breach of express contract. It's really the foundation of the entire lawsuit.
Right. And to understand this, Grok says we have to go back to the very, very beginning, to something called the Certificate of Incorporation.
Okay, let's unpack that. The core allegation here is that OpenAI betrayed its Certificate of Incorporation. Now, that sounds super formal, right? Like something you file away in a drawer and just forget about.
Yeah, legally.
But Grok flags this as the potential smoking gun. In plain English, you can think of the Certificate of Incorporation as the DNA of a company. When you birth a corporate entity, you file papers with the state, usually Delaware, and you tell the government and the public what this thing is. Is it a bakery? Is it a bank?
Or in this case, is it a public charity?
Exactly. And Musk's argument is that OpenAI was born with a very specific genetic code. It was a nonprofit. Its sole purpose was to benefit humanity. It wasn't designed to make money. It was designed to, save the world.
Right. So Musk is saying, I funded a public benefit mission. I didn't write a check for a closed source corporate giant. He poured what, somewhere around $44 million into this entity based entirely on that genetic code.
It's the difference between donating to build a public library and investing in a bookstore.
That's a great analogy.
If you give me money to build a library for the town, and 5 years later I put a turnstile at the front door and start charging everyone $20 to get in,
You're going to have a problem with that, a big
okay,
problem.
that's the perfect analogy. The accusation is that Sam Altman and the other founders took this nonprofit DNA and they mutated it. They shifted to a for-profit model. They stopped sharing their source code, which is where the closed source complaint comes from.
Huh?
And, maybe most damningly in Musk's eyes, they licensed their intellectual property exclusively to Microsoft.
It's the exclusivity that seems to be the real sticking point. It's not just that they're selling the tech. It's that they gave the only key to one specific corporation.
Right. Musk is essentially on record saying, you broke the deal. You took the public's money and my money, and you handed the keys to the kingdom to Microsoft. But this is where it gets complicated. OpenAI's defense is pretty blunt.
What are they saying?
They're saying, show us the contract.
Show us the contract. That feels like a lawyer's favorite phrase. So they're arguing there was never a formal binding agreement.
That's the core of their defense.
Right.
They argue there was no single binding founding agreement. They claim these were just informal discussions between friends and colleagues who were excited about an idea.
So they're basically saying, we had a vibe, we had a shared dream, but we didn't sign a piece of paper that said we will never, ever make money.
You can't sue over a vibe. That's their position.
But wait, there's a massive twist here with some emails, right? I saw that in the notes. This is where Grok really dug in deep.
Yes, and this is a critical part of OpenAI's defense. It's their counterpunch. They claim that Musk himself supported a for-profit transition in emails way back in 2017 and 2018.
Oh, wow.
So they're arguing this wasn't a betrayal at all. It was a necessity that Musk not only understood, but actually endorsed. They say the shift was absolutely essential to secure the billions of dollars in funding they needed to build these massive models.
Billions for GPUs and compute power.
Billions.
Yeah.
Funding that Musk allegedly refused to provide himself.
Ouch. So their narrative is, Elon, you knew we needed billions to compete with Google. You wouldn't write the check, so we had to find someone who would. You can't be mad at us for surviving.
That is their narrative. Precisely. We had to do this to keep the lights on, and you knew it. But Musk has a rebuttal to that, and it's very, very specific.
Which is?
Read the fine print.
The fine print of the emails.
Exactly.
Yeah.
Musk isn't denying that the emails exist. He's arguing context. He says his emails were conditional. He might have been open to a for-profit arm, but only if the original open mission was preserved.
Okay, so he's saying I didn't sign off on a profit-maximizing entity that is basically a subsidiary of Microsoft.
Right. He is drawing a very clear line in the sand.
Mm-hmm.
He's saying that agreeing to a sustainable business model to pay for servers is one thing. That is not the same as agreeing to hand the keys over to big tech and close the doors on the public.
So I agreed you could, sell tickets to the library fundraiser to keep the lights on. I did not agree you could turn the library into a private, members-only club for Microsoft executives.
That's the distinction he's making. He views the final restructuring as a clear breach of those enforceable commitments, specifically because of the exclusivity and the closed-source nature.
That distinction between sustainability and a total sellout, that is going to be what the jury has to wrestle with. It's a classic he said, she said, but with billions of dollars and the future of intelligence hanging in the balance.
And speaking of billions of dollars, let's follow the money.
Yeah, that brings us to Section 2, the money trail. This covers arguments 2 and 4 from Grok's list, fraudulent misrepresentations and unjust enrichment.
Fraudulent misrepresentations. It's just a polite legal way of saying you lied to my face.
Pretty much. The setup here, according to Musk, is that Sam Altman and the other founders lured him in, they sold him on a vision.
And with that vision, they got his money, specifically that $38 to $44 million, and they got his reputation. And we have to remember, back in 2015, having Elon Musk as your co-chair, that was the ultimate recruiting tool.
Oh, absolutely. If you're a top AI researcher at Google or DeepMind and Elon Musk calls you and says, come work with me, we're going to save humanity, you take that call. His name was a talent magnet.
Exactly. And Musk argues they got all of that, the money, the credibility, the talent magnet, by promising a perpetual nonprofit. He's arguing that they looked him in the eye and swore this would never be about profit.
But the allegation is that they were planning the for-profit flip all along?
A long time. That they're playing 4D chess, while Musk thought they were just playing a friendly game of checkers.
And this is where we get to the really juicy stuff. The smoking gun evidence. The notes mention something called Brockman's diary. This sounds like a plot point in a John Grisham novel.
It really does.
Yeah.
So Greg Brockman, one of the co-founders, former president of OpenAI, Musk's legal team claims there is a diary entry or maybe a series of notes that serve as evidence of internal admissions.
Admissions of what?
Admissions regarding the moral issues of the transition.
Moral issues. Wow. That implies they knew what they were doing was questionable, doesn't it?
That is exactly how Musk's team is framing it. If you have a diary entry from a key founder who is wrestling with the morality of a decision, writing down things like, are we selling out? Is this wrong? It suggests that the decision wasn't just some natural business evolution.
It suggests they knew they were deviating from the promise. It supports the whole narrative of deception.
Precisely. It could be incredibly powerful evidence if it holds up in court.
But OpenAI isn't just taking this lying down, obviously. What is their counterpunch regarding the funding? They aren't just saying, we didn't lie. They're turning the focus right back on Musk's wallet.
They are. They argue, first, that Musk knew the definition of open was evolving. That open meant benefiting humanity, not necessarily just sharing every line of code on GitHub.
Okay, a philosophical argument.
But the heavy hitter here is the $1 billion pledge.
The pledge. I remember this.
OpenAI claims Musk pledged $1 billion to the organization over time, but he underdelivered massively. He only put in about $35 million of that billion.
So their argument is, we wouldn't be in bed with Microsoft if you had kept your promise and funded us properly.
It's a very aggressive defense. It's basically, you starved us of capital, so we had to find food somewhere else. This is on you. It shifts the blame for the entire for-profit turned squarely onto Musk's alleged failure to fund them.
But Musk has a response to that, right?
Of course. He rebuts this by saying his pledge shortfall was a result of OpenAI's early deviation from the agreed-upon mission. Basically, I stopped writing checks because you started breaking the rules. I'm not going to pour $1 billion into a bucket that already has a hole in the bottom.
It's a chicken and egg argument. Did he stop paying because they changed, or did they change because he stopped paying?
The jury will have to decide.
And now we get to the valuation dispute. This is the unjust enrichment part. Musk isn't just asking for his $44 million back, is he? Because, let's be honest, $44 million to Elon Musk is like finding a quarter in the couch cushions.
Oh, no. This is where the numbers get truly astronomical. Musk argues that OpenAI took all that value, the research, the talent, the reputation, GPT itself, that was built inside a nonprofit, tax-exempt shell,
Okay.
and they illegally transferred it to a for-profit entity without proper compensation flowing back to the nonprofit.
Let's go back to your library analogy. It's like using charity money to build a massive, beautiful library, telling everyone it's for the public, and then once it's built, you change the sign on the door to private club and sell memberships for a fortune, keeping all the profit.
That is exactly the argument. Musk claims they transferred nonprofit value into private pockets. And because of that, he argues he, and theoretically the public interest he was representing, is entitled to a share of the wrongful gains.
And the valuation of those gains is what?
Well, according to the filings Grok analyzed, we're talking somewhere in the range of $79 to $134 billion.
Wait, hold on. Say that again. He wants a cut of up to $134 billion.
He's arguing that value shouldn't exist in that for-profit structure in the first place, or at least that the transfer that created it was illegal. If the court agrees that the enrichment was unjust, one of the remedies is called disgorgement.
Disgorgement.
It means forcing OpenAI to pay back the value they stole from the nonprofit mission.
That is just, it's mind-boggling. That kind of judgment would bankrupt almost any company on Earth. But OpenAI says their structure is legal, right? This capped profit thing.
Yes. They argue the capped profit structure is a perfectly legal, innovative way to scale the mission. They say investors get a return, but it's capped, and everything beyond that cap flows back to the nonprofit. And crucially, they keep hammering this point. Musk left voluntarily. He abandoned the nonprofit back into 2018, so he has no claim to what happened afterwards.
Which brings us perfectly to the next section. Why did he leave? Because the story of what happened in 2018, that is the pivot point for this entire conflict.
This is section 3, the ego and the exit. This is the breakup, and like any bad breakup, both sides remember it very, very differently.
OpenAI has a very specific and, frankly, very compelling narrative about why Musk walked away. They say it was all about power.
They paint it as a failed power grab, a boardroom coup that didn't work.
What are the specifics?
They claim Musk came to the board and said, essentially, we are falling behind Google. We're going to lose this race. The only way to win is if you give me absolute control.
And what did that control look like?
According to OpenAI's filings, he demanded three things.
Mm.
One, the CEO role. Two, majority control of the equity. And three, and this is the really interesting part, family involvement in AGI governance.
Family involvement, like having his brother Kimball on the board of the most powerful AI company in the world.
That's the allegation. OpenAI portrays this as Musk trying to turn OpenAI into his own personal kingdom, maybe even merge it with Tesla under his sole command. And when the board's Sam Altman, Ilya Sutskever, the others, said no, he took his ball and went home.
It's the classic, if I can't be captain, I'm not playing argument.
That's the picture they paint. It's a very clear story of ego. But Musk's narrative, it's
Yeah.
completely different.
Of course it is. He doesn't see it as an ego trip. He argues it wasn't about power for power's sake. He says it was a safety measure.
Exactly. He claims he sought control because he saw where things were heading. He saw the drift towards profit, the drift towards cutting corners on safety. He wanted to protect AGI from misuse. He views himself as the guardian at the gate.
So, in his version, he sees himself as the one person who could keep the AI aligned with humanity. It's, I need the keys to the car because you guys are about to drive this thing off a cliff at 1,000,000 miles an hour.
Right. And in his view, his exit wasn't abandonment. It was a protest against what he calls bad faith asset transfers. He is basically saying, I didn't leave. I was pushed out because I was the only one standing in the way of you selling out.
This all bleeds into argument 8, the tortious interference claim. Musk is saying that after he left, OpenAI actively worked against his interests.
Yeah, he claims they poached talent aggressively, specifically from his companies like Tesla, and made exclusive deals that were designed to hurt his ability to compete later on with a new AI venture.
But OpenAI's rebuttal to that is pretty standard Silicon Valley stuff, right?
It is. They basically say hiring people is legal, it's industry standard, we have no evidence we did anything improper other than, being a more attractive place to work.
It's the classic defense. It's not sabotage, it's just business. If your best engineers want to come work for us, that's your problem, not ours.
Yeah. But let's talk about the 800-pound gorilla that's been in the room this whole time. The partner that Musk seems to resent the most in this entire scenario.
Microsoft.
Section 4. The monopoly accusations.
Okay, so this is where the legal battle turns into like an antitrust thriller. Musk isn't just saying they broke a promise, he's alleging a full-blown conspiracy.
This covers argument 5 and 6 from Grok's list.
Mhm.
Anti-competitive conduct and aiding and abetting fiduciary breach. Musk claims there's a conspiracy between OpenAI and Microsoft involving these exclusive IP and compute deals.
And the goal of this conspiracy is what exactly?
To restrain trade. To lock down the market so tight that no one else can breathe. And he's very specific. He argues this is designed to harm competitors, like his own new company, XAI.
So he's saying you guys teamed up to pull the ladder up behind you so no one else can climb it.
Correct. He argues that by locking up all the massive server farms you need to train and run these models, and by locking up the core intellectual property, they're creating an illegal bottleneck in the market.
And he goes even further with the fiduciary breach claim. He's pointing the finger at the OpenAI board.
He is. He claims the board, especially after that whole chaotic episode where Sam Altman was fired and then traumatically returned, is now completely compromised, that it prioritizes Microsoft's profits and strategic goals over the original nonprofit mission of benefiting humanity.
I mean, it does feel like Microsoft is everywhere in this story. They have a non-voting seat on the board. They have the exclusive license. It's sometimes hard to see where OpenAI ends and Microsoft begins.
Musk argues that the board dynamics prove that the nonprofit mission is effectively dead. If the board is filled with people who are beholden to the massive commercial partner, who is actually looking out for the safety of humanity, who represents the public interest anymore?
It's a powerful point. But OpenAI has a defense for this too, right? They're not just admitting to being a Microsoft subsidiary.
No, they say these partnerships are standard practice for scaling safe AI.
What does that even mean?
They argue you simply cannot build these models, GPT-4, GPT-5, whatever comes next, without massive, massive compute power. And Microsoft has that power. They say it's not a conspiracy. It's a supply chain necessity.
A practical reality of the business.
Exactly. And then they point out a very inconvenient fact for Musk. XAI exists.
Right. Grok exists. We are literally reading a report from Grok for this deep dive.
Exactly. This is what I call the Grok defense. OpenAI argues, how can we possibly be a monopoly If you, Elon Musk, our biggest critic, are out there competing freely, you're raising billions of dollars, you're releasing your own powerful models, you have access to thousands of GPUs. If we were illegally restraining trade, you wouldn't be able to do any of that.
It's the proof is in the pudding argument. The market is vibrant, therefore we can't be a monopoly. And they even flip the table back on him, don't they?
Oh yeah, they say that his control proposals back in 2018, that was the real attempt to monopolize AGI.
So their line is, you wanted to be the king, we just wanted a partner.
It's a very sharp rebuttal. It paints Musk not as a victim of a monopoly, but as a failed monopolist himself.
Okay, wow. We are getting into the really, really heavy stuff now. Section 5, the heavy artillery. We are talking about RICO charges.
This is Argument 9, ARCO, the Racketeer Influenced and Corrupt Organizations Act.
Usually when I hear the word RICO, I think of the mafia. I think of Tony Soprano. I think of mob bosses going down for running gambling rings or extortion rackets. Why on earth is Musk throwing a RICO charge at a tech company?
It is the nuclear option in civil litigation.
Yeah.
It's designed for organized crime. And if you win a RICO case, the damages are automatically tripled.
Tripled.
But to use RICO, you have to prove a pattern of racketeering activity. It can't just be a one-time thing. Musk is accusing OpenAI of racketeering via wire communications.
It's a wire fraud.
It's essentially, yes.
Yeah.
The argument is based entirely on that long con theory we talked about.
Yeah.
He is claiming that the entire sequence of events...
Walk me through it.
Okay, so step 1, make public nonprofit promises. Step 2, send emails and have calls wire communications soliciting millions in donations based on those promises. Step 3, do the profit flip, transferring all that value to a private entity. Musk's team argues that this entire sequence constitutes a pattern of wire fraud.
So every email asking for money, every Zoom call where they said, we are open and for humanity, he is categorizing that as a criminal act of fraud that's part of a larger conspiracy.
Yes, he is arguing it wasn't just a business pivot. It was a criminal enterprise designed from the start to trick people out of their money for private gain.
That is incredibly aggressive. And he links this to Argument 7, the violation of a charitable trust. He calls the current OpenAI structure a facade.
A fake front.
Yeah.
A Potemkin village. He argues the whole confusing structure of OpenAI, the non-profit board that allegedly controls the capped profit arm, which in turn licenses the IP to a holding company. It's all a sham.
A sham to do what?
To circumvent tax rules and charitable trust law. He says they are funneling donated assets, which should be held in a public charitable trust, into private pockets.
That is a very serious accusation. Misusing charitable assets is a fast way to get a state's attorney general involved. This isn't just a civil dispute between billionaires anymore. It borders on criminal logic.
It does. But as you can imagine, OpenAI dismisses this entirely. Their official response is to call the suit harassment lacking merit.
Right.
They maintain the nonprofit core is intact and that all their communications about the structural changes were transparent and legal. They're basically saying, you're just throwing spaghetti at the wall to see what sticks. This isn't the mafia. It's a startup pivot. Get over it.
Which brings us to the final major argument, the one that, in a way, touches on the public perception of OpenAI more than anything else.
Section 6, the philosophy of safety.
This is Argument 10, false advertising and unfair competition. But this isn't about selling a toaster that doesn't toast. This is about selling the concept of safety.
This is the marketing war. Musk alleges OpenAI falsely advertised itself to the public, to regulators, and to him as being safety-focused.
And his logic is what? That you can't truly prioritize safety if you are also prioritizing profit.
That's the core of it. Grok pulled a key line from the argument. Lies about nonprofit status undermine safety. Musk is arguing that the moment you start chasing the dollar, you stop chasing the truth. And in AI safety, the truth about a system's capabilities and risks is the only thing that matters.
And he's got examples, right?
He points to things like the dissolution of the original superalignment team at OpenAI as proof that safety has taken a back seat to shipping products faster and beating competitors.
It's a compelling philosophical argument. I mean, if your bottom line depends on releasing GPT-5 to beat Google's next model or Anthropic's next model, will you really hold it back if you find a potential safety flaw, or will you rationalize the risk and ship it anyway?
That's the fear he's tapping into. But OpenAI's defense here, it gets personal again. They basically deploy what Grok calls the jealousy defense.
Jealousy.
They argue their safety commitments are genuine. and have produced real, tangible advancements, like RLHF, the reinforcement learning from human feedback system that keeps ChatGPT from being a toxic mess most of the time. And then they characterize Musk's constant attacks not as genuine concern for the future of humanity, but as stemming from XAI's competitive jealousy.
You're just mad because our robot is smarter and more popular than your robot.
In a nutshell, yes. They are painting him as a sore loser. They're saying he's using the court system and safety concerns as a smokescreen to slow them down because he's behind in the race to AGI. They are arguing that his safety concerns are just a convenient mask for his competitive anxiety.
Wow. So we have covered the broken promises, the money trail, the ego battles, the monopoly accusations, the RA2 charges, and now the philosophy of safety. It is a dense, tangled, legal and ethical web.
It might be the most complex legal knot in modern tech history. It touches everything: contract law, fraud, antitrust, charitable law, existential risk.
So let's synthesize this. We're sitting here in January 2026. The trial is just a few months away. What does this all mean for us, for the listener?
Well, first, just think about the irony we started with. We just walked through this entire complex legal landscape using a breakdown provided by Grok, an AI. This AI gave us the most structured, logical analysis of a trial that is going to determine the future of all AI.
It's like the AI is watching its own parents fight it out in divorce court. It's analyzing all the arguments to see who gets custody of the future.
It really is. And for you, the listener, the so what here is huge. This matters so much beyond the billionaires. This is not just about whether Elon gets his 44 million back or gets a slice of that $100 billion pie.
No, this is about the model for the future of intelligence itself.
Exactly. This trial will help determine whether artificial general intelligence AGI is treated as a public utility, something that belongs to the nonprofit world, like the Internet protocols or GPS, or if it is a proprietary product, locked behind the walls of a for-profit corporation, accessible only through a license from Microsoft.
Is it like electricity, which is a regulated utility for all? Or is it a very specific brand of battery that you have to buy from one specific store?
That is the fundamental question the jury or the judge will have to answer. If Musk wins, it could force OpenAI to open source everything. It could shatter the Microsoft partnership overnight. If OpenAI wins, it validates the capped profit model as the de facto and maybe only way to build AGI.
And I want to leave everyone with a final provocative thought, something that really stuck out to me in Grok's analysis, something that it seemed to highlight implicitly.
Go for it.
We talked about those conditional emails way back in Argument 1. The idea that Musk allegedly agreed to a for-profit shift, but only if the mission remained open.
Right. The condition, the fine print.
So if the court decides that condition was real and was breached, it raises a massive, massive question. Does the legal definition of open belong to the person who wrote the check, Musk, or does it belong to the entity that wrote the code?
That is a profound question. Does funding the mission give you the right to define the mission forever? Or does the mission have to evolve with the reality of building the technology? Who owns the definition of an idea?
And here's the even spookier thought. If Grok 4.1 is analyzing this case right now, digging through these arguments, ranking them, does it know that it's analyzing its own potential future legal standing? If Musk wins, does that set a precedent that could force Grok itself to become open source one day? If OpenAI wins, does the closed proprietary model win forever?
It's analyzing the blueprints for its own cage.
Exactly. And on that slightly terrifying note, we're going to wrap up this deep dive.
It is going to be a wild spring in that courtroom.
We will definitely be watching. Thanks for listening to the deep dive.
Stay curious.